revised application in February 2025. And then they continue to say in paragraph 9, there is thus no pending appeal before the Constitutional Court of the Schultz judgment, and any intimations of assertions by the state in that regard are false and serve only to mislead this Honourable Court. Now, this type of vexatious attacks on the state has been ongoing since the beginning of this trial. Actually, even before that, in applications to the High Court and Constitutional Court and so forth. Now, this is not the manner in which legal proceedings should be conducted. And the state is now at the point where we demand an apology for this kind of false allegations against the state. Because there is a case before the Constitutional Court. We're just waiting for a date or a determination by the Constitutional Court when and if the state will be heard. So to say that we are misleading this Honourable Court is totally false. Paragraph 11, page 5. Again reference is made to a question of fact. I say again, it is a clear example of a question of law. Each one of those 6 questions that we formulated are questions of law. As I said, legality is a crisp example of an issue in law. Paragraph 18, 17 and 18 on page 7. I must say, amazingly, the following is stated: the state furthermore did not place the judgment in Spachni before the judge at any time during the trial within the trial, nor was the judgment referred to once in oral argument by the state. Now, even if reference had been made to this unreported judgment, it is right that the SCA's judgment and Schultz and so forth and so forth. Now, and then in paragraph 18, importantly, it is, in addition to the above, it is not for the state to bring new evidence or new arguments in favour of its case in the trial within a trial at this stage. Now, that's now clearly in reference to our quoting of the Spachni case. But ironically, that is precisely what the respondent did in their arguments in the trial within a trial at the end. Only at that stage, and that aspect is canvassed in our application in detail, only in argument at the end of the trial within a trial, after we have submitted our arguments, this Schultz argument was brought forward.
Was the Spachni matter not discussed in the Schultz judgment?
Yes, but I'm referring to the criticism.
No, I know, I'm just asking. I was just wondering, because as far as my memory goes, the Spachni matter was taken into consideration in the Schultz judgment.
Yes, ma'am.
Thank you, you may proceed.
Thank you. Now, that's why I say the respondent only raised the Schultz matter in my reply, or the state's reply, after the state argued at the end of the trial within the trial. Only at that stage the Schultz issue was raised. Now,
was the Schultz judgment not handed me as an exhibit earlier?
yes, my lord, but not by the respondent. It was like a side issue by counsel for accused number 13, Holders, who handed it in. There was no basis laid for the respondent at any time during the trial within the trial on the Schultz matter. It was not part of the plea. It was not part of the cross-examination. Not that it would have helped anything, but it was only raised after my argument. And then the respondent goes further and says the state's attempt at creating a new case with new evidence, it's not evidence, it's a judgment by the SCA. Don't know why it's called evidence. In the form of allegations of pending Schultz appeal before the Constitutional Court and introduction of the Spachni judgment under an application for reservation of questions of law is wrong. How it can be wrong, I can't even fathom. Paragraph 20. On page 8, it is stated, this is a material error of law on the part of the state as an application in terms of section 319 is not an appeal. Now, clearly with respect, the respondent does not understand the law. This is not an appeal. I cannot understand this line of argument. Paragraph 21. Again, all the arguments made by the state under paragraph 4 ought to have been made in oral arguments during the trial within a trial. Instead, the state focused its energies in defending the senior state prosecutor's unconstitutional actions instead of making sound legal arguments as to why the extradition was lawful. Again, and we demand an apology from the respondent in this regard. This vexatious type of litigation is uncalled for. The fact of the matter is, the state is now criticized because we did not adduce all these arguments. But I say again, and our application is very clear. The Schultz matter was never the basis on which the trial within a trial was called for. So, I said it there in reply, the state cannot be blamed for something that was not pleaded, that was never an issue. I even told the Honourable Court, with respect, that we cannot start calling witnesses ABC up to Z for in case such argument might be brought forward at such a late stage. That is not how the law works. So, my Lord, in summary, with respect towards the respondent, these papers filed by them does not take this matter any further. They cannot tell the court that these are not questions of law. And the questions of law, as I stated, as formulated by the state, is crystal clear. And as recently as yesterday, the Supreme Court of Appeal in the matter of the state and Tabete and 7 others, again indicated precisely in a very, very thorough and complete judgment, indicated what questions of law are. This is a prime example of questions of law. And it is my humble request, our humble request on behalf of the Director of Public Prosecutions, that the Honourable Court formulate the questions of law as stated in our papers, in our application, because it is not only for the applicant to request those questions of law, the state, or rather the court, has to formulate the questions formally for consideration by the Supreme Court of Appeal. Thank you. If there's anything else, my lord, I will address you.
Thank you, Mr.
Thank you, my lord. My lord, what has happened here during the state's oral arguments is exactly what happened in our trial within a trial, where the state had a case to make, and instead of making that case, a tangent was instead gone on, in which the senior state prosecutor utilized that time to defend himself against what he perceives to be attacks by us in the papers. My lord, could I please request, so that we do not get another situation where the state claims that they did not have audi alterum partem, they did not have an opportunity to make certain averments, and they did not have an opportunity to make their case. Could the state make their case? Because they have not made their case.
Yes, but Mr. Zendaysen has said that the papers in their application
Yes.
are before the court, and
Yes.
we stand by it. And he said that it is clearly stated what the state's case is.
Yes, yes. I had to say that, my lord, just so that we do not get another instance where we make our case on the law and we bring up points that the state might have overlooked, or the fact that their case is not indicative of any points of law, and then they still want another bite at the cherry to say, no, they had not considered that, or that was never stated. So we will go through their grounds, which are stated at 2.1, at page 3. So we will go through their grounds, and we have to start with the Schultz judgment, my lord. The Schultz judgment is not presently before the Constitutional Court. As we stated in our papers, the Schultz judgment was an application for leave to appeal, was sent to the Constitutional Court on the point of remedy. So not on the legalities or the legal principles that were espoused by the Supreme Court of Appeal, but on the fact that that remedy has retrospective or prospective application. It was sent to the Constitutional Court in September 2024. In February, my lord, for reasons the state has not brought us into their confidence on, this application was withdrawn. It was never reinstated, my lord. And one will note that in the state's presentations, or even on the papers, they do not tell us when this application was reinstated, because it was not. But be that as it may, my lord, be that as it may, the concerning issue that a prosecutor for the state would claim that a fact is when it in fact is not. Be that as it may, even if the Schultz judgment was before the Constitutional Court currently, it was not before the Constitutional Court when my lord made his decision, nor was it before the Constitutional Court when Ms. Cholota was extradited. It was only, if one looks at the sequence of dates that they set out in paragraph 7, the appeal was only, or the application was only filed with the Constitutional Court in September 2024. She was extradited on the 31st of July. So as at 31st of July, the Schultz judgment was valid and binding. There was no appeal on it that could have suspended its operation. And when my lord made my lord's decision, the application before the Constitutional Court had not been reinstated, as we still maintain. It still has not been reinstated. The NPA is in the process of reinstating it, but it has not been reinstated, and so there is no appeal that is presently before the Constitutional Court. And one will note that there is no document or paper or email that the state has placed before this court to say this is from the registrar, the appeal was reinstated, and it is presently before the Constitutional Court for determination. We're all working on the intention of the NPA, and it is an intention that is an afterthought, my lord, not the actual fact of the matter. And one will note that that is noticeably absent in any of the state's papers. But, as we're saying, Lord, even if that was before the Constitutional Court, it does not change the legal position. What the SCA did was interpret the Extradition Act to to say that it conferred its powers on the minister and not the NPA. If one were to have a look at the Extradition Act currently, that is not what it states. So the legal position still remains, regardless whether the Schultz judgment is before the Constitutional Court or not. Because even on what is before the Constitutional Court, it is the narrow issue of the prospective or retrospective remedy. Now, where they want to say this applies is they want to say that by the time the Schultz judgment was decided, the SCA had, or rather by the time the extradition request was made, the SCA had not yet decided on the Schultz judgment. But even there they are wrong, my lord, because as we will recall during the trial within a trial, we set out the various instances that the United States took issue with the extradition application as it was. And so at any point in those instances, it could have been brought to the United States' attention that the law has changed. And even after, they state, my lord, in their own papers, that the judgment of the magistrate, this is at page 8, my lord, paragraph 7.5. They state there, on 7 June 2024, the judgment by the District Court of Maryland was handed down, in which Judge Magistrate Anselin found Ms. Cholota extraditable. 7 June 2024. That was after the Schultz judgment had been decided and had entered into law, and no appeal was pending before the Constitutional Court on 7 June. So that means, and one will recall, my lord, when we looked at the magistrate's order and the reasons in that court, they said that what they considered was the state prosecutor's affidavit, the investigating officer's affidavit, as well as the forensic report, which means the state prosecutor could have also deposed to an affidavit to place before the magistrate. There was nothing stopping them. There was nothing stopping them. The judgment was in force at that time, and the NPA had taken part in that. And so even if we were to leave aside the fact that this judgment is before the Constitutional Court, it takes them no further. They still don't explain to us why at any point they never brought this judgment and its implications before the United States authority, nor do they place before us anything that shows that they were ever in possession of authority, executive authority, to make that request. So the legal position still stands, and that is why we quoted Mahmoud in our papers, because it says that if the reservation of the question of law will not take the issue any further, the court has to exercise its jurisdiction, and it has to rule against the state. And so if we say, regardless whether or not Schultz is before the Constitutional Court, the legal position still stands, then Malon's decision still stands as well, because it was based on the legal principle that a state organ with no requisite executive authority to make or to exercise a function, where it has exercised such function, this court is well within its rights to say that that function or the exercise thereof was unlawful, which is what this court did. And so it will be moot to take this question to the Constitutional Court to say, did I apply the law right when I said that the National Prosecuting Authority does not have the requisite executive authority to make this decision? Because that does not need the Constitutional Court to tell us. That is the law. And so the placement of the hinging, rather, of all their argument on the Schultz judgment and the fact that for some or other reason this judgment is before the Constitutional Court and that miraculously cures everything is neither here nor there. Is neither here nor there. Even if the court could say that Schultz applies prospectively, it does not change the fact that when the extradition happened, that was the law, and the NPA was aware of that, and the NPA could have ratified it by telling the minister or telling the United States that the position has changed and requested some type of a leeway on that regard to cure the possibility of that irregularity. But that never happened. And they still don't explain to us why they never told the United States that they did not have the requisite authority to make these applications according to this judgment, notwithstanding the fact that they were part and parcel of these proceedings in the Constitutional Court. So on that first 2.1, my lord, just because they say something is a question of law does not make it a question of law. It actually has to be a question of law. And so 2.1, they fail, my lord, because the court did not misdirect itself or err in the application of the decision in Schultz, because that is not all that the court did. The court applied the actual law, which is that that functionary, that organ of state, is not clothed with the requisite executive function to make or request extraditions. So it's not to say that that is all that the court did, that it applied Schultz. It was applying the legal principle. And the state knows about this, my lord, because in the following paragraphs, and that would be at page 12, at paragraph 26, they state there that in the middle of in the second part of the sentence, while accepting that the learned Judge Quo was correct in paragraph 12 of his judgment in finding that the doctrine of legality, the rule of law, customary international law, and the Constitution lie at the heart of the question before the before the court. Because indeed that was the question before this court, not whether or not Schultz is applicable, whether or not the extradition was lawful. And Schultz was applied in getting to that decision. But that was not the mere basis of this court's decision, nor was it incumbent on the respondent, accused number 17, to state in its making of the assertion in the special plea that the extradition was unlawful, to state, oh, we rely on Schultz for this assertion that the extradition was unlawful. We did not need to do that. We stated quite clearly and succinctly in our special plea that the extradition was unlawful, and it was incumbent on the state to prove that the extradition was lawful, and it failed to do so. It brought two individuals that had no bearing or no role played in the extradition whatsoever. And so on 2.1, my lord, there's no question of law there. There's no question of law there. First of all, the Schultz judgment was not in effect and legally, was rather the appeal of the Schultz judgment was not in effect when Ms. Cholota was extradited, nor was it in effect when my lord made the decision. It's only now that we hear that it is before the Constitutional Court, when in fact that is not the case. Even as currently as now, if one were to call the registrar of the Constitutional Court, they would be informed, as we were, that there is no appeal that is presently before the Constitutional Court on the Schultz matter. And we put the state to the proof thereof, that there is in fact such an appeal. And they will come up short because there is not. There are intentions, there are lofty plans, but there is no appeal currently before the 11 justices of the Constitutional Court. But even if it were, it is neither here nor there. The legal position still stands. On the second ground, whether or not the learned judge erred in upholding the special plea and granting the aforesaid declaratory relief in circumstances of this case, relying on and instead failing to distinguish the facts pertaining to the respondent's extradition from those applicable in Schultz. It was not incumbent on this court to distinguish Schultz from the facts of this matter, my lord. That onus was on the state. The onus was on them to prove their case. If there was a distinguishability, they had to bring that to this court's attention. It was not this court's job to do the job of the state for it. They ought to have said, this Schultz matter that was presented up as an exhibit is distinguishable on the following grounds. But they did not. And so to make that claim here that it is distinguishable is neither here nor there. But even there, my lord, this is a question of fact as to whether or not it is distinguishable, not a question of law. On 2.3, whether or not the court, whether the court erred when it overlooked the important dicta of the Supreme Court of Appeal in the unreported decision of Spagni versus Director of Public Prosecutions. This indictment of the court is rather unfortunate because there was no overlooking by this court, because there was no Spagni judgment that was presented to this court for it to overlook. And so to claim in an application that this court overlooked a judgment as though such judgment was before it is regrettable on the part of the state. My lord, when one looks at Spagni, and I'm not sure that it was in fact looked at, if I could just read from the final paragraphs of Spagni, wherein they tell us what the case is about. At paragraph 26 of the judgment, my lord, the justice that wrote that judgment indicates there that the appeal was determined on the basis of mootness. Mootness in the sense that Mr. Spagni waived his rights in the US and voluntarily came back from South Africa. Now, we know from the facts of Ms. Cholota that that is greatly distinguishable because that was not her reality. She was brought back to this country before the whole nation under armed guard with Interpol and Hawks and all other manner of police. That was not a voluntary or a waiver. It was the minister. The court never entered the fray there. The Schultz matter was the first time the Constitutional Court definitively went into this and made that determination as it did. But the acting Deputy Judge President, Justice Dambuza, in her concurring judgment, in the same Spagli judgment at paragraph 27, puts it to bed. And she states there, "And I too confine myself to the issue of mootness and make no pronouncement on the merits of the appeal." So even on the content of the judgment tells us that the Constitutional Court judges never went into the merits. And so even if the judgment had been placed before Malord, and Malord had, as they state, overlooked the judgment, Malord would have been well within his rights to overlook it because it was not applicable. It was based on mootness. It was not based on who had the requisite executive authority. And so on 2.3, there's no legal question of law to place before the Supreme Court of Appeal on this score. And then we get to 2.4, the finding, whether the court opposed finding at paragraph 16 of the judgment that the prosecution had not proved beyond reasonable doubt or at all that there was a valid or lawful request from the RSA for the extradition of the respondent was correct in law and circumstance. Now this is quite perplexing because the state knows that it did not place any evidence before this court in relation to the legality or lawfulness of the extradition. And so it knows that it failed beyond reasonable doubt to prove that. And so that it would then question whether this court was correct in its finding that it failed to prove beyond reasonable doubt. It baffles the mind for this to be a ground, because unless the state can point us to any evidence that it led before the trial within a trial, wherein it showed this court or attempted to show this court that the extradition was lawful, in the absence of such evidence, indeed, it failed to prove its point beyond reasonable doubt. It is not something that ought to be referred to the Constitutional Court, to the Supreme Court of Appeal, for the Supreme Court of Appeal to look at. It's quite clear, even on the most cursory reading of the evidence that was transmitted by the state in that case. Then 2.5, whether the court of appeal was correct in allowing counsel for accused number 17 to only raise the authority of Schultz for the first time in closing arguments and entertaining such arguments, and then deciding the matter solely based on the SCA authority in Schultz, depriving the state of audi alteram partem being the fundamental aspect of the rule of law. Again, an unnecessary and unfair indictment on this court, because the court did not deprive the state of audi alteram partem. That is, in fact, that would be a serious misconduct on the part of any judge of law to deprive a litigant of audi alteram partem. That is not correct. After we made our oral submissions, the state stood up and the senior state prosecutor made replying statements. That was his audi alteram partem. That he did not take that opportunity to respond is neither here nor there, and no fault of the respondent nor any fault of this court. Certainly not a fault to the point of making it a question of law. It simply was his election not to deal with that issue in reply. But quite apart from that, that was not the first time the Schultz issue was raised. It was handed up as an exhibit, and it was handed up as an exhibit without any objection from the state. Now, that the senior state prosecutor now attempts to define that as a side issue, I think that was the terminology, a side issue by HODIS SC, which I also doubt HODIS SC would take kindly to. It was not a side issue. It was in the furtherance of the claim that the extradition was unlawful because of the conduct of the NPA, its prosecutors, and the investigators. That was always our case. We never changed it. We never altered it. That was always the case, that the extradition was unlawful and that it was rendered unlawful by the conduct of the NPA and the prosecutors in making that extradition. That we use the Schultz case as justification for why we state that. That's any legal representative and any litigant's right. And we do not need to bring court decisions before a court and adduce them as evidence in order for them to be used in a court of law. That's not how it works. It is evidence that is tested, but a case law is authority that stands. It's not something that needs to be submitted into the court for the testing, whether or not it is correct or not. It either is or it is not. And the Schultz judgment was the legal position that was, at the time, used to justify our position, and rightly used to justify our position. And so there was no audi alteram partem that the state was denied. And nor was this the first time. Perhaps that was the first time that the state heard it, but that was not the first time that that argument was made. With 2.6, whether the learned judge erred in overlooking and failing to consider the provisions of Section 172 of the Constitution. Once again, this court was never appraised with Section 172 by the state for it to overlook. And so the assertion that the learned judge erred in overlooking it cannot stand, my lord, because this was never their case. It was never their case in during the trial within a trial, nor was it their case in oral argument. This is something that is coming in fresh within this application. And so our assertion that this is new evidence and new argument really indeed is true, because there was no overlooking of anything by the court, because the state never placed anything before this court. Now, then, my lord, the rest of the application goes on about how the Schultz judgment was the only reason that this court came to its decision, and the fact that that happened is in fact a question of law. That is also a question of fact, because if my lord came to its decision using a particular judgment, that's a question of fact, that's not a question of law. A question of law would be where the court incorrectly applied the legal principles in that case. And I do not understand that to be the state's case, that my lord incorrectly applied the principles in Schultz. If that was the case, that would be a question of law. But the fact that my lord relied on Schultz in order to state the legal position as it stood, that is a question of fact. My lord could have used the Extradition Act and relied on that. That would have been a question of fact as well. It would have only been a question of law if my lord did so incorrectly. And in our response, or opposition rather, to the state's case, one of the things that we state is that the discretion, according to all the cases that we cited, and we cited quite a few. We cited S versus Khoza and Anara, that would be at page 2, as well as Attorney General Transvaal versus Kada. And in those cases, they say that Section 319 does not find application where a question of law is in reality a question of fact. That is what the state's case boils down to. Just because they claim, or they are of the view, that it is questions of law that they have in this application, does not necessarily make that questions of law. And just because they use the word legality in their oral arguments does not mean that that is what their application is based on. In fact, there's nowhere here where I see legality. And where an example of this would suffice would be where the state, their case was that it is the NPA that is clothed with the authority to make extraditions and not the executive. If that was the assertion, that would be a question of law, and that would have been them raising legality. But that is not their case, my lord. Nor do they state that that position is incorrect in any way, shape, or form. They maintain their arguments on Schultz. But Schultz said that the NPA does not have the power to make or request extraditions. It is the NPA. They do not find fault in that. But they find fault in the fact that my lord used Schultz to come to the decision that the extradition is unlawful for want of a valid request for extradition. Those two are counterintuitive, those two lines of thought. It's either the state is saying to this court that the question of law is that the NPA is clothed with the authority and not the executive. That is a question of law. And saying that my lord's reliance on Schultz is incorrect then, because Schultz states that it is the minister that has authority. But they do not say that. And so simply because they state there's a question of legality here, there's no question of legality that I was able to see in any of these pages. And then we state, we quote S versus Basson. And in S versus Basson, and we quote this at page 3 at the very top, it says there, the state has no right of appeal in terms of the act against incorrect factual findings by a trial court. The state can appeal only if the trial court gave a wrong decision due to a mistake in law. Nowhere in the application is there any mention made that this court committed a mistake in law, nor do they identify what that mistake would be. They appear to agree in the paragraph that I just read previously in the application that the court was correct in its application or its understanding of the doctrine of legality, and that the court was correct in its application of international customary law. And so if we accept that, then it cannot be that this ruling was a mistake in law, particularly when the state has not identified what mistake in law that could be. We then look at, or we then cite Dudoit's commentary, my lord, and we underline in the middle of page 3, where it says, furthermore, if the alleged question of law is nothing more than a question whether the judge had correctly considered the facts, this remains a question of fact. Now, this would be the case if the state, during the trial within a trial, or during oral arguments during which we raised the Schultz matter, my lord, had come up and said to this court, that, my lord, we wish to point out to this court that the Schultz matter is in fact before the Constitutional Court, and as a result, its operation has been suspended. If my lord had then overlooked that submission, that would be an error of fact still. But that was not what happened. They did not bring that to this court's attention. The first time we heard about the Schultz matter being on appeal was when the NPA spokesperson stated in the media directly after court proceedings. It then became their leg to stand on to bring this application for a reservation of a question of law. And even then, they do not bring this court into its confidence to say, when was this appeal reinstated? Because they accept that they filed it 4 months out of time. Then they accept that it was withdrawn in February 2025. That is public knowledge. It was stated by, I think, the head of the NPA. And so when was it reinstated? They do not tell us at all, not in oral arguments, nor on their papers. And so it can only be that it has not been reinstated, and that the assumption by the state that is that it could bind this court to an intention that the NPA has to reinstate an application. That cannot be. That's wrong in law. That's wrong in law. We're not bound by their intention, nor is the law suspended or its operation suspended simply because they say they've got an intention to go to the Constitutional Court. We then, my lord, relied on the Mahmoud judgment at page 5, and there it was about the remoteness of the application, or rather the applicability of it. So in other words, if this Schultz judgment were to indeed be before the Constitutional Court, would that take away the legal position? No. And so the reservation of the question of law is that remote, because it does nothing to the actual, not consequences, the actual result of the case. The result still is that it is the minister that has the authority, and the result still is it was the NPA that made the request. And so the result will always be, regardless of Schultz, that was unlawful. That making of that extradition was unlawful. That will always be the result, regardless of what appeal is withdrawn or reinstated by the NPA to whom. And so that ground must fail, my lord. And so we have given, my lord, in our papers multiple case law that shows the Supreme Court of Appeal's reluctance to take on questions of law, or rather questions of fact, that are clothed in that's shrouded in this mystery of being made to seem as though they're questions of law. They aren't. They're all questions of fact, and it's questions of fact that arise out of a litigant's disgruntlement with the outcome of a ruling, which is to be expected. If the court had ruled against us, we also would have been disgruntled. And in closing, my lord, I'd like to refer to 2 cases that are not on our papers, my lord, but they support the assertions that we make that none of this was before the court. in DPP Limpopo versus Molope and another, MOLOPE and another, that's 2020, 3 All SA, 633 SCA, they cite another case, which is DPP Natal.
Just down the rules. I'm trying to
20, 3 All SA, SCA, 633. And so this was a decision of the Supreme Court of Appeal, and it was citing at paragraph 9 the case of DPP Natal versus Magidela, MAGIDELA, and others. That's an unreported case, 2000 JOL 6331 A. And in that paragraph 9, where the Supreme Court of Appeal sets out this judgment, it sets out the requirements for a point of law. And the final one is that the point of law must be apparent from the record, which would make sense because the SCA would then have to look at whether or not an error of law was apparent. But this Schultz assertion, or this Schultz averment that the state makes, is nowhere to be found in the record because it was never made during the trial within a trial. And so that requirement of a point of law, it fails. And the state said there must be, this SCA said there must be certainty concerning the facts on which the legal point is intended to hinge. And there's a direct quote there that says, it follows from these requirements, so the three that they've stated in that paragraph, that there should be certainty not only on the factual issues on which the point of law is based, but also regarding the law point that was in issue at the trial. The state never placed this law issue at issue in the trial. They never informed this court that there's a pending appeal, because there isn't, but they never informed the court that there was an intention to reinstate an appeal that was withdrawn. And in failing to do so, that is not part of the record, which means that even if my lord were to refer or reserve this question of law for the SCA would be at sea as to what it is in fact supposed to adjudicate on, because that would not be apparent on the papers. And one will recall that it is notoriously frowned upon for evidence, new evidence, to be led before the Supreme Court of Appeal. There's countless cases in which the justices have pronounced upon that. And so even there, who would lead the evidence? Would it be led from the bar by the state? It would be untenable, my lord. It would be untenable. And it would be a waste of the Supreme Court of Appeal's time to look at these facts and look at whether or not this and that indeed happened. Now, in closing, my lord, I wish to cite section 3171, which we quote in paragraph at page 8. We start quoting it at paragraph 19. And towards the end of, and we quote it at the footnote at page 8, at the very bottom there, but it says there that such a special entry shall, upon application for a special entry, be made unless the court to which or the judge to whom the application for special entry is made is of the opinion that the application is not made bona fide, or that it is frivolous or absurd, or that the granting of the application would be an abuse of the process of the court. My lord, this application before this court by the state is frivolous, and it is rather absurd.
Yes, but does 370 also apply?
It does not, my lord. I'm quoting from it. I'm paraphrasing it to make this point, this final point that I'm making, that the application by the state is indeed that which was envisaged by 317, notwithstanding that a special entry is not what is sought in this case. But the legislature is quite clear. Where the state makes an application that is absurd or that is frivolous or that is a abuse of the court's processes, it must be denied. Our point simply is that this is what the case is in Kasu.
Yes, Ms. Makutala is a system. In an application of this type, is the judge's only discretion not to decide whether the application rests on point of law or point of fact. Isn't that my only discretion?
That is indeed, my lord.
In other words, if I should decide that yes, this specific point is a point of law, and now the state asked me to reserve that point of law for decision by the SCA. And in that process, I feel that that point of law has no prospect of any success when it is reserved for the SCA's decision. Can I dismiss the application?
Indeed, you can, my lord. That's what the case law says.
There.
That's what Mahmoud says in Van Rensburg. Because in Mahmoud versus Van Rensburg, my lord, because that is where they state that even if the court were to exercise the discretion, if it is of the view that the result would be so remote, and the remoteness there would be a prospect of success, that it is within the court's discretion to exercise that discretion against the state.
Anything else, Mr.
That is all our submissions, my lord.
Why, Mr. Delay?
Very shortly. My lord, it is fortunate that we live in the 21st century. Apart from, of course, speaking to my superiors at head office and the council, burdened with this appeal to the Constitutional Court, there is a website of the Constitutional Court, and there is a case number, CCT 280 of 24. The parties, the Director of Public Prosecutions, Gauteng Local Division, Johannesburg, and another versus Jonathan Schultz. This is on the website of the Constitutional Court. Just the only outstanding is the date of the hearing. Anybody, and this is a public website, anybody can.
Getting of the application for you to review.
Yes, there's just not a date yet. Section 317 has no application in this matter, none whatsoever. And apart from that, we've not heard anything warranting further arguments. Thank you.
It's now almost 10:30, and I would like to consider the submissions made by the respective parties. I intend to hand down my ruling at 3 o'clock this afternoon if it is inconvenient for any of the council who are excused from attending at 3 o'clock as long as there is someone representing the parties like an attorney. Court will then adjourn until 3 o'clock.